Next item on the agenda is proposed legislation to establish procedures for the use and operation of county-owned or leased vehicles. Joe, we have your name on here.
I understand that.
Give you the floor.
Well, I guess due to a long-running list of complaints and concerns from citizens over the years, asking what can be done about sometimes misuse, sometimes people not understanding if it even is a county vehicle or not. We got looking into proposed vehicle legislation or vehicle legislation policies, and discovered we really didn't have any. So I asked Mrs. Hurley to research and see what we would need to do if we wanted to have a policy, vehicle policy. And I think she's done a very good job. And she's dissected some other counties, I believe, to see what they were doing. Sent it on to Mr. Benson for his look over, and I think we came up with something. Doesn't seem to be too invasive, but it will certainly tighten up the, I guess you can call it the way the county cars are used, and if people do know whether they're whether they are county cars, that's a big point, and give some direction to the employees and to staff. So anyway, you've all been furnished with a copy of the legislation, so I guess we can open up to any questions.
Questions?
What counties did you reach out to, Ms. Laura?
So Hartford and Cecil are the two that we really focused on.
Okay.
And a lot of this language came right out of their code.
Okay. I'm just curious on what our executive department thinks about it. I mean, I know they've given us a list, but ultimately they're the ones that are going to have to be exercising this. I just I hate to pass legislation without even giving them a chance to say anything about it. This is just a work session. Have you been able to read it at all yet?
We read the legislation. Which
Yeah, excuse me. Hang on. Sorry. If you want to come up.
I'm sorry.
Yeah, that's okay.
Yeah.
It's all right.
Yeah, thank you. We have read the legislation. We talked to several department heads and several departments. In front of you, you have a list of questions that go along with this legislation. The sheriff's office is a big concern. They switch out vehicles all the time, so some of the requirements of this legislation are a little impossible for some of our departments to do. So the sheriff's office, for example, they're issued a car, but they'd be switching out for a transport, or they might be switching on the motor, or they might be driving something different for cert. So would they have to come in front of council in order to do that?
Did you all read this legislation?
We did. The only thing that
exempts the sheriff's department.
only from the titling.
No, it exempts them from.
No, we just went over it today, and the only thing that was in there for the sheriff's office was the titling.
I didn't see it either, Joe, when I looked in here.
So the sheriff's office was not taken out or exempt.
Would this be something that maybe you, first off, do you guys think that this is crazy?
I don't think it's crazy, but I don't think it's it's in the council's scope. I think it's under the executive because it's our employees daily. So we do have a policy on cars, and actually one of the things that'll be added is it's in the personnel manual. So the new manual will be given to you guys, and it's in there. So we've actually addressed it. I think some of the stuff in there, for example, you talk about licensing, that they have to have a valid state license. From which state? And I know that sounds.
It says a valid license.
It says from the state.
Yeah.
So, right, but which state? Is it Maryland, is it Delaware, or is it just a valid license in any state?
Valid license is what, it doesn't say which state.
Right, exactly. So if they live in Delaware, is that okay?
Yeah.
Can they have a so my question, so, I mean, I'm not going to read the questions, they're right here.
We're just asking, I mean, if And I appreciate you bringing that up to us.
Yeah, no problem. I don't have the list of questions in front of me. I know I put them in front of you, but just a lot of different things because I think this is the personnel of the county. It's working, its daily operations. And
Well, the main purpose of this is a lot of folks don't know if it's county cars. I get calls and say, is it a county car? And they give me a tag number. Well, I don't know, so I have to get up with the county, our administrator here and find out. So, one of the main things is that all the county vehicles have a seal on them. Is that a problem with you guys?
I don't have a problem with it. I mean, if you think that every car needs to have a seal, I mean,
The sheriff's office and the state's attorney's office
yeah, there's some that are
We
undercover.
excluded the seal part from this.
and the
That's-
state, and the state's attorney's office as
Well,
well.
I don't think we hit the state, did we do the state's attorney's
I don't
office?
think we
Because
did
they've
state's
got,
attorney.
they've got investigators.
Yeah, that's fine. It says law
I think you're
enforcement.
talking about general purpose vehicles.
It says law enforcement is excluded, yeah.
Only for titling, though. Like, that's how it was written. It might not, I mean, from the
Yeah.
version that I got, it's
We
just the title.
can change that.
Okay.
That's no problem.
So, but again, you're exempting the sheriff's office, you're exempting the state's attorney, so the only elected official that you're putting your thumb down on is me, once again. So my question is that you trust the sheriff to, for his cars and everything else, and the quartermaster. You trust the state's attorney. Why don't you trust me with our vehicles? So the seal situation seems to be an ongoing situation because actually Angie and I talked about the seals. I think this was brought up to John Pasota as well. I think there was some controversy between Bob Culver's 150-year seal. You guys didn't want that anymore, and so it needs to be switched to the original seal as opposed to his 150-year seal. So we heard that there was some controversy about that. I don't know if that's where it comes from. I have no problem making sure that the new seal is on all the, I mean, not the new seal, the original seal is on all the cars. I mean, that's fine. So,
There's other, if you've read the legislation, there's a
I
lot
did.
of things in here, about reporting, about who operates the cars. There's a lot of things in there that's not addressed in the personnel manual. So.
it is being redone. So my suggestion, I mean, if the bill was to go forward the way it's written now, I in good faith could not veto that bill because I think there are a lot of things that aren't addressed in there.
I mean,
But would you like to provide us with a list of things you would like changed about this bill?
I think the questions sort of speak for themselves because I think there was a lot of questions that I gave. For example, we talk about alcohol being in the car. I assume that meant operating the car, I would assume, as opposed to carry, because so we have Civic Center employees that would have to potentially carry liquor from the dispensary to the Civic Center. Sometimes delivery doesn't work. So there are some county employees that may have to transport it. Public Works,
Unauthorized.
that's
Maybe
just-
unauthorized.
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 Okay, well, I mean, I think that's how the system works. So like our dispensary, well, now they deliver, so hopefully they wouldn't have to do that. But I think that, pickups need to happen. I'm just saying there's little things to just make sure to keep in mind as you're going forward. Because, for example, Public Works, like one of the things that you had said is that you wanted a list, I think, of the departments and the people who are in them, and you wanted it to be brought in front of council if that was switching, like if somebody was switching vehicles or something like that, or if there was like a change or something. Like, didn't we read that? That there was like,
There's an update.
oh, there was an update?
No, that's in there. We would update the council.
Right. If
It
so,
says it was updated. It didn't say we had to give our permission.
okay, no. So my question is, so if a roads employee will be changing vehicles because they're now on the snowplow or they're now on this, or they have to take this car home for that, does it need to come in front of council?
It doesn't state that in there.
Well, I think that there are a lot of questions about, because it says if there are changes to whoever's driving what vehicles, the update has to come to council.
It doesn't say that.
No, it doesn't say that.
Did we read the right thing? I mean, it was literally in the packet. Didn't we read that?
Section D on, under 99.2, and
And I
it
don't have
says,
it in front of me.
county vehicles shall be assigned to departments or agencies of the county government by the county executive as approved by the annual budget and appropriation ordinance. Except as otherwise prohibited by law, vehicles may be reassigned between departments or agencies, not employees. So if you want to assign a vehicle from Public Works to the Sheriff's Department, you got to tell the county council that you're going to do that. but.
I just can't
but within
understand why the
public-
council feels that that's in their purview if I'm switching a vehicle.
Well, if you budget, I'm just.
Just for budgetary?
I'm just going from the hip here. If we've authorized, let's say, $1 million to planning and zoning,
Mm-hmm.
and they take a vehicle and they send it over to Public Works, all of a sudden you have a major asset that's shifted. That's it. I mean, that's just, and honestly, I'm assuming that's what the attempt is, or
Yeah,
Mm-hmm.
I
the
don't-
purpose of it is.
So this is
It's not a $5,000 car anymore. It's an $80,000 or a $50,000 truck. You know, it's like John says, it's a major asset. And, you know, talking about why we should, you know, we're the legislative body, so we do legislative matters. And when, I don't know about other council members, are welcome to speak up, but, you know, when you spend time listening to people complain about this person taking their child to daycare in a county car, or this person going to the grocery store and loading their county car up with groceries, you know, that's not what taxpayers pay their taxes for.
Right, but do you know the process of those vehicles? So for example, we have to claim whether it's business or personal travel. We pay for that. So it's a fringe benefit. Like for me, for example, when I drive to work every single day in that Tahoe, it's personal. It's 10 miles I have to claim that comes on my paycheck. Any business that I do during the day then gets listed as business. I literally turn in mileage every 2 weeks to payroll. So what I'm saying is that even if they use it, if they are assigned a take-home vehicle, nowhere does it say that they can't use it for personal, but they do have to claim those miles.
That's fine. That's what this policy is about. This is what we're tightening up. So you're not hauling your child to daycare, and I know you're not.
No, I'm not.
Anyway, you've got liability issues there. You know, when you go putting your kids in a county car and taking them somewhere, not only that, taxpayers are looking at it and say, wait a minute, you know, I'm buying a car, I'm taking my child to daycare. Why should a county vehicle be used to take their child to daycare? And this hasn't just happened since you've been here, Julie.
Yeah, I
This has
understand.
been going on for years,
I understand.
okay? And
Also, though, I really wish that the first time we were hearing about this wasn't right now. I would have loved to have had a meeting with you or any of the council that was concerned about it, and we would have gone over what the steps are, where we are now.
this is how we do it.
this isn't a work session, right?
This is
Yeah,
a work
it is.
session.
Yeah, it's just a work session.
This is what it's about.
Yeah.
This is how we do it.
So why don't we work through these questions that you have and try to get on the same page as
Yeah.
much as we can with this, instead of just
Right.
going back and forth?
Yeah, that's fine. Yeah, that's fine. Yeah, or, I mean, if you want to take these,
Now, because, I mean, I would rather I haven't had a chance to read them yet.
right. So what I'm saying is, why don't you take them, digest them, and then we can have a conversation at another
Yeah,
time?
we appreciate you supplying the list.
Yeah,
I
I think this is something definitely we need to meet with you about.
Sure.
And go through and try to get on the same page, because there's
So-
a lot of questions that you have too.
Well, and there are others coming from finance as well. So Charles just happens to be home. His baby's sick right now, so he's home with him right now.
So I just want to say before we change topics, but I just want to say, I believe Joe's intent is not, you know, any way of trying to control what you guys are doing. I think he just wants to have some sort of guideline, because we don't have one. And that's, I think that's all our intent right now, is to just have some sort of groundwork. And I think we're all willing to work to make it work for everyone.
Okay.
And I, you know, here we are. This is the first work session on it.
Well, I appreciate you calling me up, so.
Only
Yeah,
20
sure.
questions, so it shouldn't take too long to get through.
Well, I like that.
There's more coming, Joe. Sorry, from finance. I'll send them to you.
I like the idea of trying to get the seals in order. It's funny, I was at a Salisbury State of the State meeting the other night, and the individual who was in charge of procurement had a slide on the background. It was a toy truck, obviously a toy truck and all that. And she said, well, how do you know that's not a city vehicle? And everybody's kind of, well, what are you getting at? And she goes, it doesn't have a seal on the side of it. And the person next to me kicked me in the shins, and I said, well, I get it. But anyway, it was one of those moments I thought, well, that's a good point. So
Yeah.
there's some good parts to it. Yeah.
I'd say, of course, I'm glad. We've been getting calls the whole time I've been council. We've always get calls when somebody, they think they have a, a county vehicle, and they're, off in some other area picking up kids and doing something, you name it. So I appreciate the intent of doing it, as a whole. I mean, just so it's stated, as a government regulation person, I'm saying less is more. Demisclerosis, that's the word. We don't want to put in more things that different people, have to do in order to comply. But I think the more that we can provide some sort of a bit of understanding of clarity of what's happening, to know that we're tracking. I think this is a good intent. So I think we could certainly slim it down, make it look efficient, and provide our citizens to be able to say, okay, we know who's doing what, where, and that it's all transparent. I think that'll be a positive thing.
Okay.
Can you spell demisclerosis for the minutes?
Yeah, right.
And
Sound
for
that.
me.
Yeah, yeah, for us.
It sounds like something to
Yeah.
take a pill for.
Any other input, comments, questions?
Well, no, I'm fine. From what Mrs. Giordano said about paying for the car, that still doesn't make it your car.
No, but I don't want you to think that if somebody's flitting all over Salisbury, that they're not being held, like, there is an accountability piece when it comes to business and personal. So as it being treated as a fringe benefit, you do have to claim, I mean, the IRS is very strict about those rules. So we are following IRS code when it comes to that.
There's also the public impression of how the vehicles are being used too.
Gotcha, understood.
Maybe we could put something on the back saying, if you don't like my driving, call
Yeah.
443
I'm gonna put Jim's
Wicomico County. Yeah, don't put my number on there.
Putting your number
Call
on it.
James Wynn.
Yeah,
I'll call you.
yeah.
All right, thank you very
That's
much.
fine. Thank you.
Appreciate it.
Thanks.
Thank you, Joe. Next item we have on the agenda is discussion on circuit court opinion and declaratory judgment in Charter Section 315. Mr. Benson, good afternoon.
Thank you. I asked to be placed on the agenda last Thursday at 8:31 in the morning. I got a copy from the court on the court filing system of the opinion entered by the Wicomico County Circuit Court in the matter between the county executive and the county council. And we began to analyze what was in that opinion. By 9:30, it started to appear on certain news media and whatever. So this went out to the public. So for that reason, I suggested we do this in public because I thought that it was important to have everybody, including the county council, understand what was occurring. The opinion was entered by the court, and the bottom line of the opinion was that it found in favor of the county executive. But when we analyzed the opinion, what we discovered was that the court in its opinion recited the key section, which is Chapter 315, Section 315 of the county charter, which details what's supposed to occur with regard to appointments by the county executive, what positions are to be submitted, and arguably how those submissions are to occur. And in analyzing the opinion, the court set out Section 315 in its entirety. And when it did that, it appears to have it recited Section 315 incorrectly. It picked up what apparently was, a version prior to 2016. And according to the court's opinion, in the body of the opinion, it says, however, since Wicomico County adopted the charter in 2006, there have been multiple procedural methods employed. It appears that the court may have used a 2006 version of the Section 315. The relevance of that is that the charter was changed in 2016 and again in 2018. And the court did not use, or at least did not cite in its opinion, the current version of the charter. The relevance of that is that the current version of the charter has the words "at its legislative session" in the charter. The version that the court printed does not contain those words. And it appears the court in analyzing Section 315, which is a key section, failed to analyze the meaning of the term at its legislative session when it came to its conclusion. I have asked Ms. Hurley if she would put a copy of the charter, the opinion on the board, so the council has the opportunity to look at it. But if you look, this is from the court's opinion, and that's the Section 315 that it set out. And you will see that in the last couple of lines that the words "at its legislative session" does not appear. Ms. Hurley, if you would move from that to the next slide or the next matter.
Is this something that can go on the full screen for the public to review? There it is.
So this is what we filed I'll get into this in a little bit, but we filed a motion to alter or revise the opinion. But this is what I have placed in our motion to alter or revise. And what I've done in there is I've highlighted in italics, and I've also highlighted in yellow the words that the court failed to include in its opinion. And you will note that approximately 25% of the words from current Section 315 were omitted by the court. And the most important part of that is that at the bottom you'll see the words "at its legislative session" was omitted by the court. And in Thursday afternoon, after I had analyzed this with people in my office, I contacted the county executive's attorney and brought this problem to her attention, and suggested that a possible solution might be for us to jointly contact the judge to let him know that there was an issue. She indicated that she would give it some thought and get back to me. On Friday, she contacted me by email and said that she thought the more appropriate way to handle it was to file a motion to revise the opinion. So at this point, the county executive on Friday filed a motion to revise the opinion. The motion to revise the opinion that the county executive has filed, not to get into the weeds, but basically their position is that the failure to include that language constitutes what's known as a clerical error. And their position appears to be that all the court has to do is simply take out the incorrect section and insert the correct section, but not change its decision. The problem from my perspective with that is that when you analyze the court's opinion, the court did not address what "at a legislative session" means. It does not appear to have addressed or analyzed that in rendering its opinion. And consequently, since the county executive filed a motion to revise, it seemed to me that it was imperative that the county council move as quickly as possible to also file a motion to alter or amend the opinion. So at this point, both the plaintiff and the defendant are in agreement that the court's opinion is in error and that it needs to be revised. The argument at this point is what the effect of the court's error is. And in our motion to alter or amend, which I sent you all, we pointed out what we think that the error that the court made is substantive, that the failure to analyze or include an analysis of the "at its legislative session" is a substantive mistake and needs to be addressed as a substantive mistake. A clerical error, there are a couple different sections of the Maryland rules which address revisions to court opinions, and one of those is the one cited by the county executive, which allows the court to correct clerical errors. Clerical errors is not specifically defined, doesn't appear to be defined, it's not defined in the rules, and there don't appear to be a significant number of cases in Maryland in which this issue has been addressed. But a clerical error is generally understood to be a mistake such as a clerk might make, and is not an error arising from oversight or omission by the court. And the error that was made here is not in the nature of one made by a clerk. There is a Maryland case that is indirectly on point. And in that case, there was a clerical mistake was made or allowed to be addressed by the court. But in that situation, when the court entered the order, it included the words in the titling of the case, sitting as an orphans court. Wasn't in the body of the opinion, it simply was in the titling. And that was a mistake, and the court removed the words sitting as an orphans court, didn't change its opinion. But that's a clerical error. This, at least in my opinion, is not a clerical error. It's a substantive error. The court, nowhere in the court's opinion does the phrase "at a legislative session" appear, nor does it appear anywhere in the opinion that the court analyzed the effect of that language on the issue that's before the court. In our motion to alter and amend, I have included a copy of the 2016 amendment that was adopted by the voters of Wicomico County. Laura, are you able to pull that up? And provided that to the court. So just so we're clear, in 2016, the county council decided that there were changes that should be made to the county charter, among which was a revision to Section 315, and it adopted certain language, and as part of that language, it included adding the words "at its legislative session." As part of the process, the county attorney then prepares a ballot question which appears on the ballot that the voters vote on. The ballot question was question C, which is what's on the board on the screen now. And you will notice that in the last sentence, that specifically it says, and to require submission at a legislative session of council. If anything, to be blunt about it, from my perspective, question C is actually clearer as to what was intended than what ended up in the revision to Section 315. So the voters in 2016, by a margin of approximately 24,000 for and 12,000 against, adopted this and specifically said that the county executive is obligated to make a submission, quote, at a legislative session of the council. What the court has failed to do is tell us what that language means as it relates to this dispute. It has not addressed it, and consequently, we have filed a motion to alter or amend the opinion that the court has granted in this situation. This is the county executive filed a declaratory judgment action requesting that this issue be resolved by the court, and the Maryland courts have held that it's reversible error for a trial court to grant relief without making specific findings and declarations as to pertinent facts and the rights and obligations of the parties. And while a declaratory decree need not be in any particular form, it must pass upon and adjudicate the issues raised in the proceeding to the end that the rights of the parties are clearly delineated and the controversy terminated. Until the court, it seems to me at least, that until the court tells us what the words at a legislation means as it regards a submission, the court has not acted in a manner consistent with Maryland law and has not adjudicated this such that the controversy's been resolved. So at this point, both the plaintiff, the county executive, and the defendant, the county council, are in agreement at least that the opinion issued by the court has a significant error in it. the error is apparent on its face. And the disagreement at this point between the county executive and the county council is not whether an error occurred, but it's whether the error is substantive or is merely clerical in nature. And that's what the court's going to have to decide. But I wanted the council to understand what the court did. I know I sent it to you. I'm sure everybody read it. But when you read it, when you initially go through it, there are subtleties to it that I wanted to make sure you all had the opportunity to understand. And the specific issue that we have here is that I don't quite, for the life of me, I don't know how the court managed, with all due respect to the court, I don't know how the court managed to get the language in 315 incorrect. Because in fairness, both the plaintiff's counsel and defense counsel provided copies of the correct language to the court in its pleadings. It'll be interesting if we ever find out how this mistake was made. And this is a total guess on my part, but my guess is that the circuit court may have a copy of the county charter in its chambers, and it's an old copy, and the court used an old copy of the county charter when it wrote the opinion and made its decision, and somehow did not understand or did not pick up that the revisions had been made. So I thank the council for allowing me the time to explain this to you, and if you have any questions, I'm happy to try to answer them.
Thank you, Mr. Benson.
Mr. Benson, is it correct that you and the county executive's attorney did not testify to these facts? This was just mailed in or sent over or whatever?
It was, both parties submitted written memorandums to the court. The court made a decision based on the written memorandum.
Okay, so it would probably be to everyone's benefit if this was not done in person the next time, correct?
Well, that's going to be within the discretion of the court, Mr. Holloway. The reality is that there is nothing that's really at dispute as far as the substantive facts in this case. And whether there's testimony that's needed or whether there's argument that's needed, the court's going to have to make that decision. There are no substantive disputes. The facts are not unknown. The problem in this instance is the court somehow inadvertently used the wrong section and left out and did not analyze the language that's the most relevant, and that is what the term at a legislative session means as it relates to the county executive being required to make submissions of persons for appointment.
Which is really the substantive issue.
It's a central issue. I've been practicing law for more years than I'd like to admit to, and I've never seen this type of mistake. So it's unique, and that's why I asked to do this in an open session, because I thought it was important to explain what had occurred, so that, you know, most people are not going to be sitting in the courtroom if and when this happens, and they're not going to have the opportunity to read it. And I thought it was important to explain that this is what happened, that somehow the court picked up the wrong charter section, the wrong section of the charter, and used that, and appears to have used that in analyzing this. And until they analyze it using the correct language, I don't think we have a definitive answer.
So what matters is the charter, right? It's not necessarily the ballot question. It's what the charter says.
Well, the ballot question is where the charter gets its language from.
Right, but that's not what the charter says. And when I read the charter at a legislative session, I did some research on what a adverbial preposition is. And we have a list of prepositions here. One is an adjective preposition, and we have a adverbial preposition, and it's at a legislative session. And when you look up what that is, it can only modify the verb of the sentence. and the verb of the sentence is fails to act or confirm or reject any appointment at a legislative session. And then when you look at the adjective preposition, adjectival preposition is what we call that. That's the county executive, and that can only modify the noun of the sentence, and that is submission of this sentence here. And I figured this out. It's just a shame that we have to wait for a court opinion to figure this out. That's all I have to say. Thank you.
Mr. Nguyen, I'm not in a position to.
I know you're not an English teacher.
To dispute your English. I don't know that I have that
Yeah, but
ability
we pay a lot of
to-
money. We pay a lot of money for an opinion, and you should have done the grammar work first.
James, I think you're out of line with that as far as Mr. Benson's concerned. He has a law degree, and I think he's taken all that into consideration.
The only other point I'd make is that the language that the voters voted on and approved is what's in front of you in question C. What they intended is what's in question C. And I think that effectively is what the legislative history is that the court should rely on in making its decisions to what that section means. So with all due respect, the person in the black robe is going to make the decision as to whether you're right about the reading on this or not. I just wish that they had made that in the opinion when that they had not used the incorrect section when they rendered the opinion. If they'd used the correct section and we had lost, we would not be here today. But they didn't do that.
I know, but we're about 60,000 in the hole.
Not to my office, you're not. So I don't.
All together for this whole lawsuit.
I don't know the answer to
It's
that.
terribly unfortunate. We agree it's terribly unfortunate. We will agree with you on that. Thank you very much, Mr. Benson. Any other questions? Thank you again. Next item we have on the agenda, well, we're wrapping up here. This concludes the open work session. We'll now be going into a closed work session. We appreciate everybody's attention and time for being here.